Bismillahir Rahmanir Rahim. Starting in the name of Allah. Today our question is what do you mean by temporary, perpetual and mandatory injunction? On what grounds injunction cannot be granted? Illustrate your answer in the light of relevant provisions of the Specific Relief Act 1877. Okay, now we'll discuss about the answer of this question. The Specific Relief Act provides for two broad types of reliefs: remedial reliefs and preventive relief. Okay, remedial relief includes recovery of possession, specific performance of contract, rectification, etc. On the other hand, preventive relief is given by way of granting injunction. Section 52 of the Specific Relief Act 1877 says preventive relief is granted at the discretion of the court by injunction, temporary or permanent. Okay, so court can grant it by its discretionary power, and it can be granted by injunction, which may be temporary or permanent. Okay, step by step now we'll talk about injunction. Okay, now we'll see a definition of injunction. What is injunction? Injunction is a kind of judicial process whereby a party is required to do. A required to do means a mandatory injunction ought to refrain from doing any particular act, which is called a prohibitory injunction. Okay, or maintaining status quo. Granting injunction is purely a discretionary remedy. Before granting injunction, the court must be satisfied about the following. 1. Prima facie case. Applicant must make out a prima facie case. Okay, second, irreparable injury or loss. Prima facie case alone will not do. Okay, the plaintiff must also show that he will suffer irreparable injury if the injunction is not granted. Okay, last of all, balance of convenience. The balance of convenience must be in favor of the plaintiff. Okay, now we'll talk about type of injunction. That means how many kinds of injunction. There are different kinds of injunction. Temporary injunction, perpetual injunction, mandatory injunction, and according to CPC, we can say there was mentioned about an injunction which is ad interim injunction. Okay, but in a Specific Relief Act, we only can get three types of injunction. For the reason we will discuss about this three types injunction. Okay. Temporary injunction. Temporary injunction is an order by which a party to an action is required to refrain from doing a particular thing until the suit is disposed of. Okay, temporary injunction is an order by which a party to an action is required to refrain from doing a particular thing. How long? Until the suit is disposed of or until further order of the court. Okay. According to Section 53 of the Specific Relief Act 1877, temporary injunctions are such as are to continue until a specified time or until the further order of the court. They may be granted at any period of a suit and are regulated by the Code of Civil Procedure 1908. Temporary injunctions are dealt with in Order 39 and Section 94-95 of the Code of Civil Procedure 1908. Okay. Now we'll talk about a perpetual injunction. Perpetual injunction is an final order by which defendant is perpetually enjoined from the assertion of a right. So here perpetually enjoined from the assertion of a right or from the commission of an act which would be contrary to the rights of the plaintiff. So that act must be contrary to the rights of the plaintiff. Okay. Section 53 of the Specific Relief Act 1877 says a perpetual injunction can only be granted by the decree made at the final hearing and upon the merits of the suit. The defendant is thereby perpetually enjoined from the assertion of a right or from the commission of an act which would be contrary to the rights of the plaintiff. By perpetual injunction, a defendant is perpetually restrained or forbidden from committing an act which would violate rights of the plaintiff. Section 54 of the Specific Relief Act 1877 provides about the circumstances in which the permanent injunction is granted. Okay, now we'll talk about a mandatory injunction. Mandatory injunction is an injunction by which court directs a person to do certain acts which he is legally required to do. According to Section 55 of the Specific Relief Act 1877, when, to prevent the breach of an obligation, it is necessary to compel the performance of certain acts which the court is capable of enforcing, the court may in its discretion grant an injunction to prevent the breach complained of and also to compel performance of the requisite acts. Okay, and also to compel performance of the requisite act. Okay, on what grounds injunction cannot be granted? Now we'll discuss about second part of discussion. The court has discretion to grant or refuse injunction. This discretion is, however, not arbitrary or capricious. Court should weigh the amount of substantial mischief done or threatened to the plaintiff and compare it with those which may be inflicted upon the defendant, if granted. Thus, injunction may not be granted on the following grounds. Okay, number 1. Injunction will be refused if the suit is prima facie barred by principle of res judicata. The court will not grant injunction if it has no jurisdiction to entertain the suit. To restrain persons from applying to any legislative body. Next, to interfere with the public duties of any department of the government or with the sovereign acts of foreign matter. Next, to stay proceedings in any criminal matter. Next, to prevent the breach of a contract, the performance of which would not be specifically enforced. Okay, so we have to understand that contract which is not actually specifically enforced. Okay, next, to prevent on the ground of nuisance, an act of which it is not reasonably clear that it will be a nuisance. Next, to prevent a continuing breach in which the applicant has acquiesced. Next, when equally efficacious relief can certainly be obtained by any other usual mode of proceeding except in case of breach of trust. When equally efficacious relief can certainly be obtained, by any other usual mode of proceeding except in case of breach of trust. Next, when the conduct of the applicant or his agents has been such as to disentitle him to the assistance of the court. Last of all, where the applicant has no personal interest in the matter. For understanding better, now we'll see an illustration. A seeks an injunction to restrain his partner B from receiving the partnership debts and effects. It appears that A had improperly possessed himself of the books of the firm and refused B access to them. The court will refuse the injunction because here B is guilty. His application is not actually legal. For the reason, the court will refuse the injunction. And he won't pass an injunction in this matter. That's all about injunction. Thank you for watching this video.